Trusts are highly misunderstood, but are a central tool within an estate plan. So I thought it would be helpful to do a multi-part series on some of the common and maybe not so common trusts that are used in estate planning and build on that knowledge for the benefit of one, individuals who might want to implement or update an estate plan, or two, advisors who want to learn more about trust planning, especially because financial advisors are going to have to know more and more about trusts in the future. Then finally, attorneys who want to get into estate planning or brush up on their skills might find this helpful as well. So today is the first in a multi-part series on common trusts used in estate planning. And as a first, I'm going to use the same set of slides for two actual talks. So I'm going to get as far as I can get in 10 minutes today, and then kind of wrap things up in another episode based on today's central themes and topics. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. So for today's episode 209, it's part one of a series on common estate planning trusts. Now, as always, I want to emphasize that this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. And I want to highlight that too, because I know there's going to be individual clients listening to this. There's a lot of nuance to this, especially based on state-by-state analysis of laws. So what works in one state may not work in another state, so it's imperative that you always check with an attorney and/or tax advisor before doing anything. Now, a quick note from me, our sponsor, Griffin Bridgers. What do? I provide tailored estate planning and tax education to audiences in the financial planning world and audiences in the legal world. So, this channel stands as a testament to my experience as a speaker and educator, but beyond that, I've got 10 plus years of teaching financial advisors through the College for Financial Planning and teaching continuing education programs for a variety of bar associations, financial planning associations, estate planning councils, and for Stratford publications. Beyond that, I love speaking and teaching and sharing my craft. If I was independently wealthy, this is how I would fill my days, as weird as that sounds. So if you'd like to leverage my passion and my expertise as an estate planning speaker to differentiate your firm, practice, organization, or financial institution, please email me at griffin.bridgers@gmail.com. Now back to the presentation. Now, a big part of education and trust, I think, is really sales education. And, I'm going to make some advisors and attorneys angry on this, but good. I think you should be made angry on this because you're doing things wrong if that's the case. But I want to emphasize that trusts are often misunderstood and viewed in a black and white manner, and that's solely for sales purposes. People want to give you the extreme view to create urgency and close a sale, and that's not in your best interest. So, there's a couple thoughts you might have heard that are really on two opposite ends of the spectrum. One is maybe that you must have a trust to avoid an extremely expensive probate proceeding and create privacy for your estate plan. That's a valid point, but it's on one extreme. You also have an antitrust view that trusts are bad. They tie up assets for decades, they create complexity and should be avoided. That's on the other extreme. Both of those are extreme viewpoints which don't emphasize nuance, and there's always nuance, especially in the legal world, but nobody wants nuance because nuance doesn't close sales. So if you see an advisor or an attorney taking any of those extreme views, that should serve as a red flag that your interests may not be best served. You need somebody who can explain those nuances. By no means will we cover all nuances today. You need to go to somebody else to have all the right nuances you need to make the right educated decision. Now, if we're going to break down trust, the best way to do it in terms of how you would design and implement an estate plan is to understand the difference between a revocable trust versus an irrevocable trust. Now, first off, the purposes are different. A revocable trust is the most common type of trust you see used in estate planning, and its primary purpose is avoiding court interference and limiting that, and it has a secondary purpose of creating some privacy. Now, those two goals are often stated as absolutes. You can't avoid all court interference, but you can seek to limit it, and the revocable trust is a tool used to do so. Similarly, you can't create absolute privacy, but you can create some privacy, and the revocable trust can be a tool for that as well. Now, the utility of the revocable trust, at least during life, stops there or shifts over to the irrevocable trust, which we'll talk about in a second. But before we get to that, a big key difference between the two, but beyond the purpose, is the extent to which you can change the revocable trust. So if you create a revocable trust, your legal term, you are a settlor or a grantor, sometimes a trustor or trust maker. But if you're the creator of that trust, then the fact that it's revocable means that, one, you can revoke any transfers to that trust. So if you put property in, then you can take that property back out at will. Similarly, the terms of the trust in a written document can be changed by you at any time as long as you're of sound mind, if you're the settlor of that trust. So, the difference between that and an irrevocable trust is that an irrevocable trust is permanent with respect to transfers to that trust in most cases. And the reason the transfers to that trust are permanent is because it serves the main purposes we have here, which are creating tax savings or protecting assets from creditor claims, either with respect to the settlor or the beneficiaries or both. Now, there is a lot of nuance to that creditor protection question, and that's all we're going to really address here. It's way too complicated to really get into the weeds, especially on this basic discussion here. But you make permanent transfers to an irrevocable trust because it aids those two purposes of tax savings and creditor protection. Now, the terms of the irrevocable trust are largely permanent and can't be changed, but modern trends in estate planning and in state law that governs trusts have altered that so that these trust terms can sometimes be changed. They're more set in plastic instead of being set in stone. But any transfers of property are permanent and can't be taken back by the settlor, at least without having an exchange of equal or greater value out of the settlor's own balance sheet or assets. So, one key distinction here is that the revocable trust is only revocable during the life of the settlor. Once the settlor is deceased, the revocable trust becomes an irrevocable trust. So all trusts that we create during the estate planning process are eventually at some point going to become irrevocable trust. The difference is how we get there. So, in order to know how we get there, we need to know when the trust is created and under what type of document it's created. So, a trust that's revocable can be created during life, but that's usually the only time you create a revocable trust, at least with respect to the settlor. You could give beneficiaries powers over the trust that make an irrevocable trust become, in essence, revocable. But most of the time when we're looking at revocable versus irrevocable, we're looking solely to the powers that the settlor of the trust might have. So, because of that, when the settlor dies, they no longer have the ability to revoke a trust. So, most trusts at death become irrevocable with respect to the settlor. Now, revocable trusts are pretty much always created during life because of that exact point as well, that the settlor has to be alive to be able to revoke a trust. So you're always going to have a revocable trust created during life, but you can have irrevocable trust created either during life or at death, or both. So how do you get there? Well, with a revocable trust, it's usually created with a separate standalone document called a revocable trust agreement. It's signed by two parties. It's signed by the settlor and it's signed by the trustee. Now, the settlor is usually the trustee of the revocable trust as well. But the key picture is under state law, you have to have settlor and trustee sign off on the creation of this revocable trust. Now contrast that with an irrevocable trust where the settlor is rarely, if ever, going to be the trustee. You're usually going to have a separate trustee to make sure that the transfer to that type of trust is permanent to serve those tax saving and asset protection goals. So with this, you can have an irrevocable trust either created during life under a separate standalone instrument, or it could be created at death either through a revocable trust document because, like I said, the revocable trust becomes irrevocable at death, or it could be created through a will as well. Now, trusts created under a will are always going to be irrevocable, and they're known as testamentary trusts. They're always going to be funded through that will through the probate process as well. So, as next steps, what we're going to look at in the next part of this series are learning about how we fund the revocable trust. We'll look at a comprehensive view of how assets flow at death based on a certain hierarchy, which you'll be surprised to learn puts your will last in the line. We'll also wrap it all up to learn how we integrate wills and revocable trusts as part of an estate plan to serve those goals of avoiding court interference and improving privacy. And then finally, we'll look at this comprehensive chart of how everything flows as well to tie it all together. But this is a good stopping point for today's part 1 of Common Estate Planning Trusts. Now, as always, if you have non-client related questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.